For the record, this matter is before the court on the plaintiff's motion for entry of a qualified domestic relations order. In addition, a hearing is scheduled on an alleged contempt violation of a restraining order, mutual restraining order on the part of Mr. Aaron Carlson. This hearing is being conducted via Zoom. The president is Attorney Bonita Huffman, representing the plaintiff Teresa Carlson. Ms. Carlson is present with Ms. Huffman. In addition, Aaron Carlson is personally present. Typically, the domestic matter of the court would allow that to be conducted via Zoom, but since we had a contempt hearing for an alleged violation of restraining order, the court ordered Mr. Carlson personally appear. Mr. Carlson's court-appointed attorney, Timothy Leiter, is also present. The court was informed Mr. Carlson is asking for an adjournment to talk to an attorney.
Your Honor, that, if I may, Your Honor, that is my understanding, Mr. Carlson. Mr. Please sit down. Of course, there's an issue over the quadro and things like that. Your Honor, I've done maybe 3 or 4 family law cases, so I don't feel that I'm the best possible person for him to have any family law in a financial matter. So that's why he's decided.
Sure. And you're pointing to represent just on the criminal contempt.
Exactly.
So what about that matter? Can we talk to something about the contempt proceeding? Can we address one of the 2 matters today?
I haven't had a chance to. We've had some discussion with this office. I don't think we've had anything that would lead to a fruitful resolution at this point.
Ms. Huffman, you met with the front of the court, Mr. Carlson, regarding this request for the quadro, correct, to collect unpaid outstanding spousal support?
That's correct, Your Honor. Mr. Carlson owes about $204,000 to my client out of an obligation of $288,000. And he has requested the opportunity to speak with an attorney regarding the qualified domestic relations order that we are asking for.
Okay.
Obviously, we object. We'd like to proceed with it today. The other thing is that in the interim, we'd ask that the court order that Mr. Carlson not access the 401k or any other retirement account that he has pending the hearing, so that none of the funds are secreted or removed.
Well, and you're essentially asking the court to enter an order that the 401k would pay to your client spousal support that's owed, correct?
That's correct. But we're also asking at this point, in light of Mr. Carlson's request, that if the court grants his request to obtain counsel for this hearing, that he be ordered not to access that account.
Understood. Understood. I'm just trying to understand your request. Sort of unusual request. I don't think the court's seen that very often, where you're asking the entry of an order that directs the plan administrator to make payments of that 401k to your client. Is that correct?
So we're looking for a lump sum amount, Your Honor, because of the fact that it is being taken from the retirement funds. We would like to get the entire amount that's due to my client, even any future payments, so that we don't have to keep coming back here and doing this. Mr. Carlson has successfully avoided making payments by switching jobs.
I've read all the pleadings. So will the plan administrator comply with such an order, Ms. Huffman? It's very unusual. I mean, Mr. Carlson is not in pay status, is he? He's not collecting that retirement.
I'm sorry, I didn't hear you, Your Honor.
Do you believe the plan administrator would comply with an order of this court?
I do, Your Honor. Under ERISA, it can be accessed for support purposes. That's an approved division.
Okay, all right. All right, Mr. Carlson, after you've known about this for a couple weeks, why haven't you talked to an attorney before? Now you're asking at the 11th hour to ask for him to talk to an attorney.
No, sir.
And you didn't get a copy of the motion that was filed by Ms. Huffman?
No.
Ms. Huffman, did you mail a copy of the motion notice hearing to Mr. Carlson? He's claiming he had no idea what you were asking about before.
So we sent the motion by email and by regular mail to all of the addresses that we had. And I believe an additional copy may have been sent to Agent Sharp, but I sent the motion to Mr. Carlson at the email address he's always given for service.
Okay. Looks like your mail But Ms. Huffman indicated she emailed the pleadings to
I
you.
haven't gotten it, and Mr. Sharp, yeah, I just seen him 2 days ago.
Who's Mr. Sharp?
I appreciate you, Your Honor.
What are you on probation for?
And, receiving, and he has done
Okay,
nothing about this.
is that here in Monroe County?
Yes, sir.
All right.
And he hasn't mentioned anything, he hasn't got anything.
Well, he wouldn't receive civil motions.
Well, she said that she mailed a copy.
Okay, well, I don't know when you last saw your agent.
2 days ago now.
In any event, the court was just informed Ms. Huffman by Ms. Patrick there's an outstanding bench warrant for Mr. Carlson's arrest. In any event, the court was just informed Ms. Huffman by Ms. Patrick there's an outstanding bench warrant for Mr. Carlson's arrest. I think it goes back to, and I'm surprised if he's on probation, that the probation officer wasn't aware of this.
I'm aware that there's a bench warrant for his arrest. I'd ask to be taken into custody and arrested.
All right, Mr. Carlson, it appears that he failed to appear for a review hearing with the front of the court. It looks like back in mid-2023. This has been outstanding for a period of time. I'm surprised Agent Sharp wouldn't inform me of that or clear that up. But there's 2 deputies here. Court has no alternative but to have you taken into custody. This bench warrant requires a $5,000 cash bond. So
I was in jail, Your Honor, in Mahoney County, and that's why I missed the court date. I went to court Judge Brown when I pled to the receiving, and he gave me 6 months to clear up all warrants. Now, outside in my briefcase, I have paperwork.
do you have $5,000 in your briefcase?
No, but I have paperwork showing that I was in jail,
Okay.
and that was why they told me.
You should have taken care of this rather than waiting for the full 6 months to take care of it. You should have taken care of it like promptly when you get out of jail, Mr. Carlson. But of course, no alternative. You've got to be taken into custody at this point in time. Ms. Huffman, I guess we need to we'll set a new date. I mean, the court's very busy. I don't have time to keep adjourning matters. I'm reluctant to adjourn the matter, but if Mr. Carlson wants to communicate with the attorney, do you now have a copy of the motion that she's filed?
No.
All right. All right, to Ms. Huffman, maybe you can mail a copy to him at the Monroe County Jail. I don't know.
I can.
It's a $5,000 cash bond. Do you think you can post that, Mr. Carlson? It's going to apply toward these arrearages. All right. Do you have an attorney that she can mail these pleadings to?
Mr. Sharp, I guess.
No, he's not an attorney. What she's asking for is an order that requires the plan administrator for your 401k to pay to Ms. Huffman the spousal support you owe about $180,000. That's what she's asking for. And the other thing on the contempt, you have an order that says do not communicate, don't text her, don't call her. I don't know what you don't understand about that, Mr. Carlson, but that's the basis for the contempt hearing. You want to proceed with that?
Your Honor, I do.
Your Honor, if I could, and I apologize to the court, this may not be artfully stated, may not even be proper. Apologize to Ms. Hoffman too. But in a criminal setting, there's a thing, and I know the court knows this, called the COPS evaluation, where we get a chance to sit down and talk it over. The judge indicates to the parties what the possible sentence would be. I don't know if that's permissible in this setting or not, but if it is.
Yeah, it's not, court doesn't have time for that.
I understand, Judge.
So I don't know, what does Mr. Carlson want to do about these allegations? He's obviously received a copy. This court, I believe, mailed him a copy of those to appear personally for the contempt and sent him a copy of the petition. It's alleged by Ms. Carlson that Mr. Carlson was texting her. I think it was a joint account with Ms. Carlson and the daughter, but the restraining order prohibits any communication.
Your Honor, I've had a chance to confer with Mr. Carlson. Of course, we're very mindful of the court's time. The court wants to be as economical as possible. I find I would prefer having these things handled all in one fell swoop as opposed to bits and pieces. Is it possible to do the restraining order violation at the same time when we come back to the
They're unrelated, totally separate, totally separate.
Your Honor, I've talked to my client who wishes to proceed with the hearing.
All right, gentlemen, I'm sorry to have both of you over here. Can one of you remain here? We'll take some brief testimony. I thought we're going to adjourn it, but I'm going to take some brief testimony to at least to deal with the restraining order violation.
Yes, Your Honor.
All right. Thank you, Deputy Peters. Thank you. All right. Mr. and Mrs. Carlson, can you both raise your right hand to be sworn, please? Do you both solemnly swear or affirm that the testimony you're about to give us matter will be the truth, the whole truth, nothing but the truth, so help you God?
Yes, Your Honor.
Ms. Carlson?
I do.
Thank you. All right, Ms. Huffman, we will adjourn to another date your motion for the entry of the quadro on the retirement. And at this point in time, yes, the court will, if you want to prepare an order, the court will order. You can send an order to the plan administrator that there should be no withdrawals from that 401k until order of this court.
Thank you, Your
At
Honor.
least hold things in place to protect your client. But if you want to proceed with testimony on the alleged violation of the restraining order, please.
Thank you. Ms. Carlson, would you spell your name for the court reporter, please?
Just a minute. I'm sorry. Mr. Leiter had a question.
Your Honor, if I could ask, would it be possible for Ms. Hoffman and Ms. Carlson to exchange seats? Because I see half of her face. I don't get a chance to see the whole face. I think it's important to be able to evaluate veracity.
Okay. Maybe you can move your device.
Is he having trouble hearing me?
No, I'm having trouble seeing your client, and I think that's important.
Is that better?
Can you move the court's screen?
Yeah, that's.
There's only one screen for, if we had two people in different screens, I could, but I can't be doing it.
Can I proceed?
Maybe if she can move closer to you, Ms.
Ms.
Carlson.
Yes.
That's better. That's better. Thank you. All right.
Would you state your name for the record, please?
Teresa Kathleen Carlson.
And would you spell your last name for the court reporter?
Ms. Huffman, you're gonna have to get closer to your device. We can hear the answers, but not your questions.
Got it, Your Honor. Thank you. Can you spell your last name for the court reporter?
Ms. Huffman, I'm sorry, we cannot hear you.
Okay.
I guess it's a one-person device, so you gotta go pass it back and forth, I guess.
Okay, can you hear me now?
Absolutely.
All right. Would you spell your name, please?
Carlson.
Okay, now we can't hear your client. Why don't you, all I can do, maybe you can call and hear by audio. Mr. Leiter wants to see your client's face. But you got to handle it some other way, Ms. Huffman. You can't hear.
You know what? I have an idea. Give me 1 second.
Okay, we're back on the record. Ms. Huffman, you can begin again with your examination of Ms. Carlson, please.
Your
Yes.
Honor, I'm really sorry to interrupt. I was interrupted before this, but just to let you know, I've had a chance to talk to my client. My client has had a change of heart and that he wants to plead and get this going and move in the right direction.
All right, did you hear that, Ms. Huffman?
He's going to plead, is that correct?
Yes. Apparently he's going to admit to contempt. All right, Mr. Carlson, is that correct?
Yes, Your Honor.
Are you satisfied you've received the right to legal counsel by conferring with Mr. Leiter?
Yes, Your Honor.
Okay, the allegation before the court is that you violated a mutual restraining order, which was entered on February 3rd, 2021. It was approved by you as well as Ms. Nemec, your attorney. Do you want to copy that order? Okay, and that order, among other things, and that was in exchange for dismissal of the personal protection order. It said neither party shall phone or contact the other party in any way, including social media. And it's alleged, the courts are saying the allegation, Ms. Huffman, is that Mr. Carlson was texting his former wife, Teresa.
Yes, Your Honor, and sending messages by mail.
Okay, let me reference the date. What was can you recite for the record the allegation?
Your Honor, there were messages sent from September 29th of 2023 up and through January of 2024.
And these were text messages from Mr. Aaron Carlson to Teresa Carlson.
Yes, as well as letters that were mailed to her residence.
Okay. Did Ms. Carlson at any point in time ask him to refrain or stop with communication?
Your Honor, the restraining order says that he's not to contact her.
I
His
understand. The
daughter,
question is, Ms. Huffman, I understand what the restraining order says. Did she engage in any conversation with them, or did she ignore the messages or tell them not to communicate?
she did, but then there was one email or text message in which she told him that all communication should go through the attorneys.
Okay, all right. Okay, Mr. Carlson, do you understand the allegation?
Yes, sir, Your Honor.
And of course, you have right to a hearing. You have right to hear from Ms. Carlson. You have right to have Mr. Leiter question her, cross-examine her. Do you understand that?
I understand, sir.
If you admit to these violations, there will be no hearing. Do you understand that?
Yes, sir.
All right, you've been sworn. State your name for the record.
Aaron Carlson,
Okay, do you have a current mailing address, Mr. Carlson?
not yet, Your Honor.
Okay, is this still a valid email address? UP 10798 @gmail?
Yes, sir.
Okay. You admit, acknowledge, you violated this restraining order by communicating with Teresa Carlson by text as well as written letters.
Yes, sir.
And you admit, acknowledge that was contrary and in violation of this restraining order.
Yes, sir.
All right. All right, the court finds, will accept Mr. Carlson's guilty plea to contempt, his admission that he violated the restraining order. The court will only find Mr. Carlson to be in contempt of court for doing so. Ms. Huffman, when was the day of the last communication?
I don't remember when that was.
I believe the last one was in January of 2024.
Okay. All right, so is there anything, what's your request for the court at this point in time? Are you requesting jail?
Yes, Your Honor, we are. The messages are such that it would cause a person to be concerned about their personal safety. Even the messages that he sent that were intended for their daughter conveyed hate and contempt for my client, as well as threats to get even and to punish Kirsty. There was also threats of exposing personal photos of my client on Facebook and as the covers of cards that he would send to relatives and friends with the purpose of harassing my client. So yeah, my client would ask for jail time. This has been an ongoing problem.
All right, Mr. Leiter, anything you'd like to say on behalf of Mr. Carlson? Would you like to address the court?
Your Honor, first of all, I think we're looking at things that happened in January. We're May 7th at the moment, so we're 4 to 5 months in. No other reports have been made. And all honesty, while my client does admit to what happened, my client does also assert that this is not just a one-way street, that he's received communication from Ms. Carlson as well as their daughter Kirsty. Now, that doesn't minimize, of course, we know that. But at the same time, Your Honor, nothing has happened at this time. And I think that it would probably be more of a deterrent to my client if the court would consider hanging some time over his head. And with any violation of that, then the court could impose that time. My client indicates to me that it's not going to happen. Of course, we all know that these situations are charged. Candidly, one of the reasons why I don't do domestic work. But at the same time, I think it would be quite a deterrent for him, knowing that if he does screw up, and knowing that the court is dead serious about these things, then there would be a very real chance of jail time if he did. So I think it'd be more of a deterrent, Your Honor, if the court would consider holding time over his head. Now, I noticed we have a deputy here, he's gonna go to court, he's gonna be taken in for contempt for missing a court date. That could also be part of the sentence here, Your Honor, initial sentence. So that's all we'd ask for.
Thank you, Mr. Leiter. Mr. Carlson, anything you want to say before the court imposes sentence?
1 minute. Yeah. 1 second, please, Your Honor.
Okay.
Teresa, go ahead.
Why?
Your Honor, did you want my client to make a statement?
Just one moment, please.
Your Honor, my client's asked that he have the opportunity to reserve the opportunity to make a statement depending upon what
Okay,
Ms. Carlson
fair enough.
says.
All right, go ahead, Ms. Carlson, if you want to make a statement.
What would you like to say? This has gone on for a long time. And at this point, I would like to see him go to jail because he's been warned many times about this and it has not stopped. Until we had to get a hold of his probation officer, we couldn't get PPOs. We talked to his probation officer and they did put a no contact order for myself and my daughter.
But there's nothing that prohibits them from communicating with your daughter. I mean, this PPO only prohibits contact with you. So, Mr. Carlson, you can text with your daughter and make sure it's not a joint account with Teresa, because that's where you run afoul.
Yes, sir.
All right. Thank you, Ms. Carlson. Mr. Carlson, you can be seated if you want. Fine.
But, Your Honor, when I mailed the letters, it was when I missed the court date.
Should be right into the court when you're missing court dates, not Teresa.
But I was in Mahoney County Jail, so the only address that I knew offhand, but those letters were not addressed. I used that address, but that was addressed to Kirsty, not Teresa. And I was talking with Kirsty, and I don't know if Teresa read them or not, but and beyond that.
Okay, I see some envelopes in here. Inmate correspondence says Teresa Christy Carlson. So they were mailed to both. If you want to see them, Ms. Huffman has attached a number of letters here from out of Cleveland, Ohio area.
I may have put both names, but Teresa knows that those weren't her. Clearly, when you read it, it wasn't her.
Don't put her name on it.
So I was communicating with Kirsty while I was in jail. Now, in regards to text messages and how they got charged, when I got out of Mahoney County, we have mutual visitation with George, the dog that was set up by this court by you 8 years ago. And then they consistently, every time I would call or text Kirsty, and Teresa was copied on those texts, but it's clear, it's blatantly obvious, anybody read those texts, that they were not texts to Teresa. So what Kirsty started doing was, refusing me to see George, and then anger started to build, and that wasn't right. I shouldn't have blocked.
George, for the record, is your dog, correct?
Yes. And so even till now, I've not seen George in 6 months. And that's why I kept texting over and over and over and telling them that, trying to set up, that's what they're not telling me. These weren't random texts. These were texts that were aimed at trying to set up the visitation with George. Then they told me, they said, and like they stated, they said, well, we don't want no communication with you. It's all got to go through the lawyer. So I called Ms. Hoffman's office. Teresa wasn't even retaining her. She hasn't retained her except for 2 or 3 weeks ago or something like that. But when they told me, when they texted and said to get a hold of Ms. Hoffman, I called Ms. Hoffman's office. Her services were not retained. So they were lying to me. They given me and even till now, they're in violation of your order. I have still not been allowed to see George.
Okay. Well, there's Mr. Carlson, I understand that, but there's ways to do that. You had a former attorney, Sonia Cannon. You could write to the court directly to ask them, file a motion, the motion for parenting time with the dog, George. There's a way to do that. And yes, if Ms. Huffman was not being paid, Ms. Carlson, she's not going to just volunteer her time to organize this. So, but then in a restraining order, maybe it should have been clear that you can no communication except for parenting time about George. But it doesn't. It says simply no communication. So understand, no communication. You've got to go through the court or the front of the court parenting time from this point forward. So this continues. I'm just letting you know. Just don't even go there. If you want to talk with your daughter, that's fine. Make sure that Teresa's not on that account.
Well, my probation officer, Mr. Sharp, gave me some good advice on how to move forward.
That's what the court's trying to do. File a motion, write to the court, or have the front of the court assist you. But in any event, Mr. Carlson, the court having found you in contempt, the court's going to order serve 45 days in jail as follows: 5 days immediate, the balance 40 days is reserved. Okay, and also I'm gonna I'll send a order over to the jail in the morning. But at this point in time, Mr. Carlson, you got this bench warrant. I'll contact Rebecca Hicks, Minoka Friendly Court Attorney. We'll try to get you have a Zoom hearing sometime this week, usually around 15, and see what we're gonna do on this bench warrant. See whether she's agreeable to reducing the bond. Right now it's 5,000 cash.
I did go see friend of the court about it, and I actually did come to your office. This would have been back in maybe.
I was not aware of the bench warrant till the front of the court informed me today. That riser still outstanding bench warrant. So that situation, we will see you again sometime this week. The only outstanding matter we have is the motion to enter the quadro. Ms. Huffman, do you want another date for that matter?
Yes, Your Honor.
You can
I
present
do,
an
and I'd
order to
also
this
like
court.
to support for attorney's fees in the amount of $3,000 for having to prepare the motion to appear twice and to defend, to litigate it.
That's that issue is reserved. We'll have Mr. Carlson come back with an attorney and they can address that, but you can submit to court an order that request for attorney fees is reserved and that the plan administrator, whoever that is for the 401k, shall not disperse any funds until further order of this court.
Thank you, Your Honor.
Want you want to give another hearing date? You can notice up. Let's give Mr. Carlson some time to retain an attorney to come back on that matter. Let's give more time.
Thank you, Your Honor. I will.
How about available on July 3rd?
I think so. I'm not booked in another court. It's the 4th of July weekend, though.
Okay, all right. Again, obviously your client will be protected with this order that you're going to submit, so there's no urgency to this 401, this quadro. So the second week of July.
I have Tuesday, July 9th at 8:30 or 1:30.
1:30, please.
Okay, so we'll put that down. If you want to, can you just renotice your motion? You may want to see whether you hear from Mr. I guess you can go ahead and email Mr. Carlson the renotice of hearing for that date, July 9th at 1:30, and hopefully you'll hear from an attorney. So contact an attorney and have him reach out to Ms. Hoffman. So, Mr. Carlson, do you have any questions? What happened today? The court on the contempt order to serve 45 days in jail, 5 immediate, starting today. And then the balance of 40 days is suspended. Hopefully, you won't even have to. You hold the key to the jail in those 40 days. And with respect to the bench warrant, it's being you're being lodged on the bench warrant issued by at the request of the front of the court over a year ago. I'm just astounded why your probation officer wouldn't have located that and made you appear. So